Welcome everyone to Maxwell Conversations, featuring high-profile international arbitration lawyers on topics in international arbitration in a way that challenges assumptions with a deeper examination of the issues. The principle of good faith permeates international arbitration. It has been used to explain formation of arbitration agreements, interpretation of arbitral laws and conventions, participation by parties in the arbitral process, and even identification of alter egos and other parties to an arbitration agreement. Yet its existence, nature, and extent is often assumed and rarely demonstrated by writers and tribunals. Is good faith an organizing principle by which all other principles can be located, or dependent on custom, practice, law, seat, and tribunal? In this third conversation, my guest is Gary Bourne, Chair of the International Arbitration Practice Group at Wilmer, Hale. He's described in many superlatives, but perhaps best known for his treatise, International Commercial Arbitration. We will later be joined by two other guests, Eva Kalnina and Darius Khambata, as we go more deeply into what good faith means in practical terms. Gary, welcome.
Thank you so much, Lawrence, and thanks again for the invitation from Maxwell Chambers to be here. It's a real pleasure and an honor.
We're very happy to have you. In your career, Gary, you have written and taught, you have acted as counsel in arbitration and in court, you have sat as arbitrator, and you have held many authority in arbitral institutions, most recently that of president of the SIAC court. Perhaps tell us what has occupied your time recently, Gary.
Most of my time during the pandemic was, I'm happy to say, as counsel in international arbitrations. I know the pandemic, COVID-19, had terrible personal consequences for many of us around the world. At the same time, for international arbitration, it ushered in not just what one might call the golden age. I think we've been experiencing a golden age since 1958 and the New York Convention. But if I can steal a bit from the airline world, a platinum age in which technology allowed disputes to be resolved in a way that was even more expeditious and efficient than historically was the case. I know that there are many different views and experiences with virtual hearings, but my own experience, and going back to your question about what it was that I was doing over the last couple of years, was taking part in virtual hearings that were, if I can use that term, virtually everywhere in the world.
Going right into the topic of good faith, at what stage in the historical development of international arbitration would you say there began to be developments of an international sense of a duty of good faith in international arbitration, and where would you say it came from?
That's a great question, Lawrence, and the audience should know that Lawrence and I haven't practiced on these various questions, so one will be getting spontaneous reactions. I don't think it goes too far to say that the obligation of good faith in international arbitration goes right back to the very beginning. We can't say that with precision or exactitude. The first arbitration that we know about was in 2650 BC, an arbitration in what's present-day Iraq between landowners, followed, according to the records that we have, just briefly, a couple centuries, by a state-to-state arbitration. And that state-to-state arbitration between two Middle Eastern principalities was, I would suggest, the beginning of good faith in international arbitration. It was a treaty between two states to resolve a territorial boundary dispute by arbitration. And although international law remained in its formative stages, its infancy, at best, I think notions of pacta sunt servanda, the obligation to perform your treaty obligations in good faith, was in existence even then. States, if they didn't recognize that obligation, wouldn't go to the trouble to conclude treaties. And I would say then that from the very beginning, the notion that a dispute would be submitted by two parties to an independent decision maker who they participated in selecting carried with it a peculiar pacta sunt servanda obligation, the obligation to, having committed to a third party, the arbitrator, resolution of a dispute. That commitment carried with it the ongoing obligation to cooperate in the future constitution of that tribunal, the future conduct of the dispute resolution process, and perhaps most importantly, compliance with the third party's ultimate decision. I think that commitment, recognized from the very outset, could be traced through the very common use of arbitration agreements between Greek city-states and then subsequently in Europe and elsewhere on a public international law level, but with the same concept being recognized as well in commercial arbitrations, where for very similar reasons, by the very fact of an agreement to arbitrate, an agreement to submit disputes for final resolution by someone chosen by the two disputants, that the simple fact of that agreement and the character of that agreement carried with it an obligation to perform it in good faith and to perform the obligations, the award resulting from it in good faith. It takes some level of inference, because the historical record obviously is incomplete. We have nothing but cuneiform tablets and papyrus fragments of treaties. But I think one can nonetheless see from even the very earliest stages the outlines and the gradual development and crystallization of a duty of good faith.
By the time we get to, say, the 18th century, where states are beginning to deal with one another diplomatically, would that have fed into the idea that when two sides engage, they should do so to that level of good faith?
Absolutely, and it's at that stage, and then subsequently the 19th and 20th centuries, that the concepts of pacta sunt servanda, the obligation to perform treaties in good faith, became more developed. One needs to rely less on inference and the nature of the obligation, and can look to more specific rulings, whether of international arbitral tribunals or the Permanent Court of International Justice or the International Court of Justice, that articulate that obligation. One also begins to see, perhaps more in the 20th century, national arbitration legislation imposing a statutory duty of good faith, while national courts, I think in particular the House of Lords decision in the Bremer-Vulcan case, began to speak expressly of a duty of good faith in the arbitration process. I think it's important to note that it would be, at least in some contexts, to talk about a duty of good faith to arbitrate. Arbitration is consensual unless parties agree to arbitrate. In many contexts, they have no obligation to arbitrate. There's no obligation of good faith in the abstract to conclude an arbitration. Parties are free to choose to arbitrate, choose to litigate, choose to do something else. Rather, what the House of Lords in Bremer-Vulcan, Swiss Federal Tribunal, and around the same time, 1980s, and but to some extent even before U.S. courts as well recognized, was that having concluded an agreement to arbitrate, having agreed to arbitrate, unless something to the contrary is said, the very nature of that agreement carries with it an implied obligation of good faith to participate diligently, cooperatively in the dispute resolution process. Arbitration, as we know, isn't identical to national court litigation, where a national court has the coercive power to force the parties to do whatever it deems best to resolve the dispute before the court. Rather, the parties, together with the arbitral tribunal, have the power and also the responsibility to formulate the arbitral procedures and then to perform those procedures. There's obviously scope for guerrilla tactics. Entire books are written about that unhappy subject, but the duty of good faith is, in a sense, the remedy for the solution to guerrilla tactics, those types of actions aimed at obstructing or delaying or producing a miscarriage in the arbitral process, violate obligations of good faith and entitle a counterparty to seek relief, in particular from the tribunal, from those sorts of abuses.
And you referred to the importance of the arbitration agreement, and that might be a good point at which to ask you my next question, which is whether there has ever been a single theory of good faith demonstrated by writers or tribunal that encompasses all the different expressions of good faith, whether we're talking about procedural good faith, tribunal good faith, anti-suit injunctions, good faith in investment treaty arbitrations, and so forth. Would you say that one can trace that or should trace that back to the arbitration agreement, or is there some other theory that supports the observance of good faith?
That's a great question, and it's a difficult question. I don't think there is any grand theory of good faith in international arbitration, like there might be a theory of relativity. I think in part that's because nobody has written or developed such a theory, but I think more importantly, it's because such a theory at anything beyond the broadest principles, such as pacta sunt servanda, would be a mistake. I think part of the attraction, part of the, if I can put it this way, part of the genius of international arbitration is that it is almost infinitely flexible and adaptable to particular circumstances. That's most obvious from what we've discussed already, in a sense, how arbitration has been used for literally 4,500 years in every conceivable type of geographical, political, cultural, linguistic, and legal setting. One grand theory to fit all those different contexts would, I think, be a Procrustean bed, an effort to force quite different types of dispute resolution suited to different types of parties in different circumstances into a single unified theory. Arbitration today is almost as varied as it has been over the last 4,500 years, comprising state-to-state arbitration, commercial arbitration between purely private entities, various types of investment arbitration, which even within the investment arbitration world can vary dramatically from ICSID arbitrations to ad hoc arbitrations, which are subject in most respects to the New York Convention rather than the ICSID Convention. A single theory of good faith to solve all problems in each of those different contexts, I think, would be not just something that nobody has written about, but something that nobody ought to write about. To force a single solution upon those varied contexts would be wrong, at least in my view. Rather, the concept of good faith is like the basic principle of pacta sunt servanda, applied on the basis of what the parties' agreement was. The parties have an obligation to perform in good faith their agreement, the focus being on them and the agreement that those two parties, or however many parties there may be, have chosen to conclude. And the obligation of good faith, it molds itself to, is derived from the terms of that arbitration agreement, and thus what's required in one context may be quite different from what's required in another context. Despite all that, I do think certain basic principles or sub-principles can be derived from an obligation of good faith and obligation to participate in the constitution of the tribunal, and conversely, not to obstruct that constitution through baseless challenges, through refusals to nominate an arbitrator if the parties have the right to do so. The obligation to fund the arbitration, to pay advances on costs when directed by the tribunal, the obligation cooperatively to participate in the formulation of the procedural rules, and then importantly on their implementation, obeying, complying with in good faith the procedural directions of the tribunal, the obligation not to present fraudulent evidence or manufactured evidence, and finally the obligation, in a sense, the cornerstone of the obligation of good faith, the obligation to comply with, to perform the award that the tribunal has made.
And yet, Gary, it is often said that international arbitration is different from court proceedings, in the sense that a tribunal does not have a court's coercive powers, whether it is to exercise jurisdiction over the parties or to compel the parties to do anything. The whole legitimacy of international arbitration relies on the fact that there is an arbitration agreement, and for that purpose, good faith is needed to plug the gaps where that are missing in comparison to court proceedings. My question would be, how highly do you rate the importance of good faith as a principle, as a theory in the workings of international arbitration?
I think the principle of good faith is extremely important. I think it's important both because it is complied with so frequently and thus unexceptionally and almost without notice, but also because when it's not complied with, it's important that tribunals, but also national courts, take steps to remedy those breaches. And let me say a bit about each one of those observations. First, we love in these types of webinars, in learned law review articles, in symposium presentations, to focus on the pathological, on the cases where things fall apart, where the center doesn't hold. In fact, in the overwhelming majority of international arbitrations, that's not true. In the overwhelming majority of international arbitrations, the parties and their counsel, as well as the tribunal, work together cooperatively in a dispute resolution process that works efficiently, expeditiously, expertly, producing an even-handed and enforceable result. Those types of cases where everything goes right and the dispute gets resolved quickly and to the satisfaction often of both parties aren't exciting. Nobody likes to talk much about them because they're not very sensationalistic. They're not clickbait, if I can put it that way, but they reflect in many ways the success of the obligation to arbitrate in good faith. Parties, often out of their own commercial interests, see the benefits to them of not being obstructive, not dragging out the procedures, not raising silly points. One sees this both as counsel when a counterparty does that, and and founders on the reefs of the arbitral tribunals rejection of those tactics. And in the vast majority of cases, that is what happens. In other cases, I would say exceptional, probably quite exceptional cases, but the ones that we often focus on, one party or occasionally both parties doesn't comply with their obligations of good faith, doesn't comply even with the express terms of the arbitration agreement or the applicable institutional rules. And in those circumstances, often one sees tribunals take quite appropriate and, if not strictly speaking, coercive actions, nonetheless actions which impose meaningful sanctions for violations of the duty to arbitrate in good faith. Take, for example, a party's refusal to pay its share of the advance on costs. Institutional rules have mechanisms for dealing with that. The counterparty can the share of the defaulting party's advance on costs in order that the tribunal can be constituted and can go forward. And then importantly, arbitral tribunals have been relatively robust in permitting the party which paid the defaulting party's share of the advance on cost to recover on an interim basis straight away the amount that they were required to advance on behalf of their counterparty, and courts have been prepared to recognize and enforce those types of awards. Similarly, when parties fail to comply with procedural directions, whether in terms of not producing documents that have been requested or failing to comply with time limits or other obligations in the arbitration, tribunals have the authority both to draw adverse inferences and to take other steps, including in many legal regimes, imposition of monetary sanctions on the party in question. I think that exercise of arbitral authority ultimately to enforce the obligation to arbitrate in good faith is well considered and positive. It is an appropriate response to so-called guerrilla tactics.
I suppose one can say that in complying with the arbitral process, that in itself is proof of the fact that good faith exists in international arbitration in a kind of Cartesian philosophical way. I observe, I comply, and therefore there is good faith. And you have spoken about several duties of good faith. I'd like to ask you about what you think about the duty to honor the award, to respect the award, also being an expression of good faith in international arbitration. Would you say that is part of the basket of duties of good faith, or something separate?
No, I think it is. Many arbitration agreements, by incorporating institutional arbitration rules, crystallize that obligation of good faith. The SIC, the ICC rules, for example, include within them requirements that the parties comply forthwith with the terms of the award that the arbitral tribunal has made. In my view, that express obligation in institutional rules merely makes express what is implied in any agreement to arbitrate. The definition of an international arbitration agreement, both from a doctrinal perspective, but also from a pragmatic commercial perspective, is to finally resolve disputes by a decision maker chosen by the parties who conduct a proceeding in which they have an opportunity to be heard. You can't finally resolve a dispute, which is the fundamental character of an agreement to arbitrate, without compliance with the arbitrator's, the third party's decision resolving that dispute. And thus, inherent in the very concept of an agreement to arbitrate is an agreement to comply with the arbitrator's final award. Thus, even absent express provisions to that effect in institutional rules, institutional arbitration rules, such an obligation is implied. And national courts take that into account in a variety of ways. Thus, in the United States, for example, even where There's not ordinarily a fee shifting mechanism where the prevailing party in a civil action would be entitled to recover its legal costs. Where a party unsuccessfully challenges an award, it will be subject to costs for that unsuccessful challenge in most cases.
Ladies and gentlemen, we are now joined by two other guests. The first is Eva Kalnina, independent arbitrator at Arbitration Chambers and members of the ICC Court of Arbitration, who has been commended for her ability to address the heart of a complex and sophisticated arbitration clearly and elegantly. The second is Darius Khambata, senior counsel in the Indian courts and in arbitration. He's also an arbitrator, and he was former Advocate General for the state of Maharashtra and former Additional Solicitor General of India. Eva and Darius, welcome. For the benefit of the audience, if you have been following closely, this conversation focuses on good faith in international arbitration, as opposed to good faith in civil law and good faith in treaties and conventions. I'd like to start off by asking the panel and Eva to start about how positive is the positive duty to arbitrate. Gary has mentioned that there is a positive duty to arbitrate and to arbitrate cooperatively. But does that mean that parties cannot adopt strategies or tactics against each other?
Thank you, Lawrence, and it is a real pleasure to be here. Thank you. So the question of whether parties have a duty to arbitrate in good faith is a question that no doubt many arbitrators have asked themselves, particularly when faced with very difficult and uncooperative parties. And I think that most arbitrators just accept it as something inherent to the arbitral process. Now, Gary has already spoken how the very existence of the arbitration agreement carries with it an implied obligation to participate in good faith in the arbitral process. It is interesting, and I've only discovered this myself recently, that actually the duty to act in good faith features very prominently in a number of arbitral rules. I was more familiar with the duty to conduct arbitration in an efficient manner, but the actual duty to act in good faith is also included in a number of arbitral rules, such as the LCA rules, CETAC rules, the Swiss rules, Vienna rules, Milan rules. And then on top of that, we have arbitral rules that then provide explicitly for the duty to conduct arbitration efficiently. And that's the ICC, the SCC, Hong Kong rules, LCA rules as well, Swiss rules. So, and I think it is fair to say as well that especially in the last 5 years, 7 years, there has been a lot of emphasis on how do we conduct arbitration more efficiently. The same way as we have spent the last 2 years discussing the pros and cons of virtual hearings, I think the main topic generally that was addressed in a number of seminars was how do we decrease time and cost? And obviously, parties' conduct is a very fundamental element in this discussion. Now, Gary has already mentioned that arbitral rules impose a number of procedural duties on the parties, such as starting from the very beginning to submit an answer to request for arbitration, to nominate one's co-arbitrator, to pay the share of advances on costs. But to my mind, we are lacking in some meaningful sanctions in cases where parties do not comply with these duties. Because generally what happens if a party fails to comply with these duties, the institution steps in. And particularly in case of non-participating respondents, nobody really alleges that the non-participating party has somehow breached its good faith duties. So the good faith principle as such, I think, is somewhat sadly a bit of an empty phrase. And I'm purposely being a little bit provocative here. Now, again, when it comes to a party's duty to pay its share of advances, yes, it is true that there are a number of arbitral rules, for example, the SEC rules that do provide that the party that has made the payment on behalf of the defaulting party may request a tribunal for an immediate award. Well, in my earlier days as counsel, I tried to convince one tribunal to do just that, but my pleadings fell on deaf ears, and sadly. And similarly, document production, yes, certainly I agree. There is always the root of adverse inferences if a party suspects that one party has not complied with its disclosure obligations. But as we all know, that can be quite an uphill battle, and the threshold to prove adverse inferences is very hard, for the simple reason that if a party has no access to the documents, for that party to find ways of proving that these documents must exist, and for the tribunal to go as far as to make a positive finding, to draw an adverse inference on behalf of that party, that is quite difficult. And I've seen cases in practice where this route has been attempted, but unless the violation somehow is really fundamental and the tribunal has no doubt that something really fishy is going on, most likely, most tribunals will tend to be quite careful. And this leads me to the point that, again, one of the topics that has been discussed quite a lot is, why are tribunals so fearful? Is there a due process paranoia on behalf of the tribunals because they are afraid of penalizing parties, of sanctioning bad behavior? And in fact, there is an IBA study by now, I think already some 5 years ago, that looked at every single or a number of different arbitral jurisdictions to find out whether arbitral awards were actually ever annulled on grounds that a party may not have been granted its fair and due process rights. And in fact, extremely few arbitral awards are set aside on these grounds. So all of this to say that duty of good faith, yes, there are many corollaries to it. There can be sanctions, but ultimately, I think that the best thing the tribunal can do to penalize bad behavior is to have specific provisions, first of all, already in the first procedural order. And by the way, the procedural orders as well, 10 years ago, they used to be just a couple of pages long, and now they become longer and longer. So the tribunals, there's a tendency on behalf of the tribunals to regulate and to become more and more prescriptive. And if during the first case management conference, the tribunal takes opportunity to discuss these matters, to precisely indicate to the parties the possible consequences of bad behavior, and that this conduct will be taken into account at the costs stage, then I think duty to act in good faith may have a bit more content. And similarly to counsel, my advice that I always give is to make sure not to forget these different episodes during the arbitral proceedings at the end. And when you do come to making your application for costs, indicate the damage, so to say, that you have suffered, quantify it, and remind the tribunal of all these bad instances allegedly due to the other party's bad behavior.
Darius, you're a seasoned litigator, and it is sometimes said that in litigation there are no pacts between lions and men. Would that not be the case in international arbitration?
Well, hi, Lawrence. Nice to be here, and to hear Gary and Eva. I'm always troubled when someone calls me a seasoned litigator, because I'm not sure that that's entirely complimentary in today's circumstances. Look, at the end of the day, arbitration in most matters seeks to resolve commercial disputes. And parties and their litigators are going to use every trick in the trade to succeed on behalf of their client. But as all of us who practice in courts know, there is a line. It may be an intangible line, but there is certainly a line. And we've always been told about officers of the court first, and only then spokesmen for our clients. So good faith is something very much on the table in court, and there's no reason why it shouldn't be on the table in arbitration as well. I think there's a distinction between utilizing defenses and objections, including of jurisdiction, which are available to parties, and acting otherwise than in good faith. I think you know it when you see it. Most tribunals would know it when they see it. And all of us have raised objections of various types and nature. But when objections are raised incessantly, when there are technical objections, you border to cross that line and go into something that is then lacking in faith. So I don't think there's, in that sense, any prescription about using all tactics available. But there are certain areas where good faith does come in. The problem always is how to enforce a duty of good faith. There's not enough sanction or power, I believe today, in the arbitral framework to actually enforce a duty of good faith. We know that tribunals do have powers, and Eva has spoken about the power of awarding costs, but that comes right at the end. It comes after the whole hearing is over, and it doesn't actually ensure that what's happened during the process of hearing has gone smoothly and always in compliance with this duty of good faith. It's difficult for tribunals to take very assertive positions because they are always troubled somewhere down the line about a due process violation. And they're also troubled about letting the conduct of a party at all influence their decision on merits. Often it can, we know that, but they certainly can't show that. So where does that leave us? I think it leaves us in a position where we have, in institutional arbitration, the institution, which has a big role to play. It can, at various stages, have an interventionist role. And in countries like India, where institutional arbitration is still somewhat of a rarity and it's all ad hoc, the courts themselves, I think you do need some sort of a sanction to make people operate in a better and more professional and a good faith manner. Gary spoke of the Bremer-Vulcan case. Of course, that's the almost like the source of modern day jurisprudence on good faith. The Indian Supreme Court in Sumitomo also spoke of an obligation, once you have an arbitration agreement, to submit disputes to arbitration and to honor the award. But as we know in practice, that often doesn't happen. There is the third, or rather the fourth dimension, and which is the elephant in the room, which is practicing lawyers, all of us. I think there is now a need for practicing lawyers also to actively assist in enforcing that duty of good faith, even of their own clients. That's often easier said than done. It's difficult in situations, but I think there is need for that as well. Of course, the Indian approach is that the Indian statute has actually built in several mechanisms to, let's put it, quote unquote, encourage good faith conduct. And this is, of course, not the time to go into that in any great detail, but you have doctrines, of course, of a group of companies where non-signatories are drawn into arbitrations, or reading clauses very widely to allow arbitration even in related contract matters or in cases of torts, etc. But you do have other very specific provisions which are based on the UNCITRAL model, which is, of course, the estoppel principle or the waiver principle, that if you sat by and allowed something to happen, estoppel or waiver steps in, and you cannot then challenge those actions on the part of a tribunal later. The Indian Supreme Court, for example, I think imposes some sort of an element of good faith in the context of interim orders from courts, for example, where there is an arbitration agreement. So one of the requirements, it's not there in the statute, it's really judge-driven, is that you would not be entitled to an interim order from unless you've shown a readiness and willingness to go to arbitration. Because all too often you have parties rushing to court to get that interim order and then just not invoking arbitration. And when you don't have an institution, it becomes quite a job for the other side to get a tribunal going. So I think yes, the answer to your question, which is, I know it's been a little longer than you expected, but yes, there is a distinction between conduct which is not in good faith and legitimate tactics and objections. And I think everyone knows it when they see it.
I'm going to ask Gary for a quick comment on Darius's point that counsel can be part of the policing force. What do you think about that?
So I unsurprisingly agree with Darius on this, as I do in most things. I think that we often exaggerate perhaps the extent to which parties misbehave in arbitration. I'd like to go back to my observation previously that although cases where parties obstruct the arbitral process or pull out every trick in the book are interesting and deserve careful attention because they're problematic and need to be fixed, the vast majority of arbitrations, in fact, don't involve that. The vast majority of arbitrations involve some hard litigation on both sides, but sophisticated counsel, sophisticated parties who recognize that the arbitral tribunal is going to resolve their dispute at the end of the day, subject to relatively little judicial review anywhere, and that appearing to the tribunal to be cooperating in good faith is of utmost importance in their self-interest. It is more beneficial to cooperate than to obstruct. There are obviously exceptions that attract our attention because they're interesting and exciting, and because they demand effective responses. One of those responses, as Darius correctly says, is lawyers fulfilling their own duty of good faith to arbitrate before the tribunal as agents for the party that is committed itself to do so. That's one of the remedies, but unlike Eva, I wouldn't say that, and I know she deliberately provoked me to make this response. I wouldn't say that the obligation to arbitrate in good faith is an empty phrase or a Potemkin village. Rather, it's one, as we know from the vast majority of cases, that is actually complied with, which in a sense is the best remedy of all, the best evidence, Lawrence, as you suggested, that this duty really exists. Parties comply with it. But also the various remedies that we've talked about thus far, as well as additional ones, are very real ones. The risk of costs at the end of the arbitration is a non-trivial one, especially for sophisticated commercial parties. Tribunals are also, at least in my experience as counsel, receptive to awarding costs on an interim basis. If a party makes a baseless application or insists upon a hearing that makes no sense, I've certainly had success in persuading tribunals to make an immediate award of costs along with dismissing whatever the application might be. Equally, I have, with some success, persuaded tribunals, with some considerable success, persuaded tribunals to make interim awards, sometimes as provisional measures, sometimes as final awards of the amount of an advance on costs that a party wrongfully failed to make. I don't think adverse inferences are an inconsequential remedy. Adverse inferences can be both explicit, but also implicit. Tribunals, when a party fails to comply with a document disclosure requests about categories of documents that are obviously relevant and material, don't forget that. It plays, and I can say this with my arbitrator hat on, it plays an important role in any tribunal's deliberations and its decision making. And thus, those remedies, as well as other remedies that we've alluded to, do give real teeth to the obligation to arbitrate in good faith. Perhaps we could come up with more teeth, dentures, to reinforce that duty. In some jurisdictions, tribunals have the authority that I alluded to previously to impose sanctions, monetary sanctions on a party for failing to do various things. There are questions about the tribunal's authority to do so, at least in some jurisdictions, but I think those questions should be resolved either by institutional rules or national law, clearly in favor of a tribunal's authority to impose monetary sanctions on a party for deliberately obstructive behavior, not for legitimately asserting rights, but as Darius said, for doing things that cross the line. And ultimately it's for a tribunal using its good judgment to decide what crosses the line.
I'd like to turn to you now, Darius, and ask you whether you consider that a positive duty to arbitrate also includes a positive duties on the parties to enter mediation, and to do so in good faith. Does it also entail the tribunal encouraging mediation and participation in good faith? What do you say?
It's hard to disagree with that proposition. Obviously, given the cost and the time involved even in arbitration, mediation or consultation between the parties, even during the course of the arbitration, is something only to be encouraged. And I don't really speak only of formal mediation or conciliation. It could be on an informal basis. The problems that one sometimes faces are with clauses that require pre-arbitration consultation. And sometimes parties tend to get very technical about how and why they've complied with those obligations. Those are really good faith duties to avoid full-fledged dispute resolution by way of arbitration, by trying to sort out the matter before you actually go to arbitration. And no one can dispute, as I said, that that's a good thing. The question is, how hard do you pitch that, and how much do you push for that? What happens in cases where that can't be done, or it would be futile, or the party has to rush to get emergency relief? Is the duty to consult, to mediate, to be elevated to the status of some kind of a condition precedent or a jurisdictional prerequisite before one can arbitrate? I think barring clauses which expressly provide so, I don't think that should really be encompassed in the duty of good faith. Different countries have different approaches. Singapore is, I know, more particular about adherence to a mediation process before going to arbitration. India has dealt with this in a more practical way by recognizing that there have to be exceptions, and futility, urgency, where you have a recalcitrant opponent. These are all exceptions to any duty to go to mediation. During the course of an arbitration, you have, of course, the arb med arb clauses, which sometimes are very effective, because if you've had a bit of arbitration first and issues have crystallized, and if you're then sent to mediation, each party already knows the strengths or demerits of its case, and that assists in mediation. But I don't think that the duty to mediate or consult can be elevated to the status where it actually interferes with the actual arbitration, or in some cases derails it. So I would put the brakes on elevating the duty to consult or mediate to that sort of level.
Eva, your view?
Well, I think it is my job here to disagree with everyone at the cost of probably embarrassing myself. No major disagreement here. I would just say that, first of all, probably the importance of mediation depends on where we find it. In other words, if it is an express term in a contract that explicitly provides that if the parties fail to settle the dispute through negotiation, then they agree in good faith settle the matter by mediation, and I think we've seen these clauses, then perhaps there would be more weight to such a duty. There are also implied terms sometimes that do not explicitly refer to good faith, but simply encourage parties to negotiate. But I think, at least in England, the courts have traditionally been quite reluctant to enforce an agreement to negotiate or an agreement to settle disputes amicably. There is an interesting case that goes somewhat in a different direction. That was before the English High Court, the Emirates Trading versus Prime Mineral Exports of 2014. And there the judge actually found that the parties' agreement to first seek to resolve a dispute by friendly discussions constituted an enforceable condition precedent to arbitration. And note there was no reference to good faith. This was only a reference to friendly discussion. So there the parties had agreed, in fact, to carry on, to resort to arbitration only after a continuous period of 4 weeks of negotiations. And I think it was Justice Dorr who found that the effect of this clause was not necessarily that these friendly discussions must last for continuous weeks, but that at least these 4 continuous weeks must elapse before arbitration could be invoked. So, but generally, I think, again, there are several obstacles here. One is, of course, what amounts to good faith, bad faith will always be case specific. And 2 further issues are, one is the burden of proof. I think it is fair to say that in arbitration, the burden of proof is probably on the claimant to show that there was a non-compliance, but that burden may shift in set-aside proceedings. And I've seen that in civil law countries, and Switzerland in particular, where then the burden goes on to the respondent in arbitration, to show that he did in fact act in good faith. Further issue is, of course, confidentiality of any settlement negotiations. So it is hard for the tribunal potentially to judge whether the negotiation was conducted in good faith or not, seriously or not, when these are off limits to the tribunal's eyes. But generally, I think that there is a consensus that the contractually agreed pre-ADR steps have to be carried out in good faith. I think both courts and tribunals will be more likely to enforce an agreement to mediate in good faith if it contains some measurable steps and some defined framework. So, for example, like in Emirates Trading, where the process was limited to 4 weeks. And while non-compliance with such steps is not necessarily proof of bad faith, but it would probably tend to shift the burden on the party that is not complying. But again, the best way to make sure that any good faith obligation is enforceable is to specifically set out the consequences for bad faith conduct in these pre-arbitral ADR in the contract. But of course, not many contracts do that.
Gary, for the sake of argument, I will suggest to you that the duty to arbitrate in good faith ends with the duty to arbitrate in good faith, that unless there is a multi-tiered dispute resolution clause or ARB-MED-ARB, no party to an arbitration agreement should be made to explore a mediatory result. What do you say?
So, Lawrence, I agree with what everyone has said and with what you just said. I agree exactly with my version of what all 3 of you have said. I think that the duty to arbitrate is indeed a duty to arbitrate in good faith. Arbitration, of course, isn't mediation, and parties are free, just as they're free to agree to arbitrate, they're free to agree to mediate. If they haven't agreed to mediate, then they don't have an obligation standing alone because of an arbitration agreement to in fact mediate, or even more specifically to mediate in any particular way. Insofar as that goes, I agree entirely that a duty to arbitrate doesn't carry with it the obligation to mediate. Of course, if the parties have agreed to mediate Eva's examples, then they have an obligation to mediate, and it may be a part of a precondition to an obligation to arbitrate. Obviously, there are issues of jurisdiction, admissibility, and the like. If that duty to mediate isn't respected, the better view, I think, is that it's an issue of admissibility. And I think English, other courts, Singaporean courts are coming to that conclusion. I do think there is an important further point, though, which is that the obligation to arbitrate includes within it the obligation to comply with the tribunal's procedural directions, as well as with the institutional rules that one has incorporated into the arbitration agreement. Some institutional rules include an obligation to mediate, or at least to consider mediation at different stages, and where such an obligation exists, then it becomes part of the arbitration agreement and subject to the duty to comply in good faith. And importantly, and I do think this is an area where maybe some differences between civil and common law jurisdictions, and also potentially some possibility for future steps towards the efficiency of the dispute resolution process. A party's obligation to arbitrate includes the obligation to comply with the tribunal's procedural directions. I see no reason that a tribunal couldn't direct the parties to mediate at a particular point in the case. It couldn't easily direct them to agree to any particular result in that mediation. I see no reason that, as part of the tribunal's general mandate to resolve a dispute expeditiously and efficiently, it couldn't direct a mediation. The mediation might be unsuccessful, but I think that would be within the tribunal's general authority. We're certainly all familiar with cases where tribunals do pretty much that, often not a direction, you must mediate, but rather a fairly forceful suggestion that commercial parties typically will heed, or at least take some steps towards heeding. Where a tribunal makes such a direction, then it, in my view, it would be subsumed within the obligation to arbitrate in good faith.
I have one or two more questions for the panel, but I'm very keen to get into the question and answer section of this event. And ladies and gentlemen, we have been watching the questions that have come in. There are questions, for example, do we have a clear, or do we have clear standards of which one can base, on which one can base while making self-evaluation that he or she did not effectively adhere to them? Another question is, isn't it necessary to elaborate more on the application of these fundamental principles in the field? And yet another similar question is, would the ability of a tribunal to enforce a duty of good faith not depend on the seat of the arbitration, or indeed what the arbitrators had for breakfast that day? I guess all of these questions have to do with whether there is really an objective standard to good faith by which one can measure the conduct of the parties. Perhaps, Eva, would you like to lead us off in that discussion?
Well, I'm surprised you're asking me, who was the most conservative about the whole good faith principle as such. I think it is probably, I don't think there are any global standards. I think it is the case, I believe Darius said that tribunals just know what it is about when they see it generally. Now, the first point, of course, is yes, you go to the arbitral seat and you go to the applicable procedural rules. And as I have mentioned in the beginning, the arbitral rules, in fact, some contain very explicit references to the duty to conduct proceedings in good faith. And I think the very first step would be also to see how if there are any arbitral awards, any precedents, any court practice on this point, and that will probably depend on both jurisdiction, it will depend on the given arbitral rules. And other than that, I think we have covered a number of elements of duty of good faith, and how it plays out in practice. But other than that, I don't think that we can speak of any global standard of duty of good faith as applied in commercial arbitration, in addition to what has already been said.
Darius, any comments?
I'm happy to agree with Eva completely on this one. I don't think it's possible to set a standard written stone. A breach of good faith is obviously fact-driven. It will change from case to case. And what might be a legitimate objection in one case might, given the character of a dispute, be a completely illegitimate in the next. So it's not advisable to lay down one standard. I think Gary's alluded to that right at the beginning. But of course, as Eva has told us, different rules provide for different things, sometimes expressly for good faith obligations for certain matters. Different countries might have certain things in their national statutes, but overall, no, there's no question of laying down some kind of inflexible global standard of good faith.
So Gary, very much up to the tribunal?
Not at all. Let me give my version for just a moment. First, let's take some things off the table, including particularly the breakfast dishes. The application of the obligation of good faith does not depend on what the tribunal had for breakfast or lunch and dinner for that matter. Arbitration is about application of the rule of law, tempered by strong pragmatic commercial experience. That doesn't have anything to do with breakfast, lunch, or dinner, and therefore tribunals should not, and in my experience, don't make decisions about good faith or other things based upon their culinary preferences. The second point, I agree very much, and tried to say this in my opening remarks, that the obligation to arbitrate in good faith depends on the parties' agreement, depends, including institutional rules that they may incorporate, and on national law, sometimes which imposes either statutory or common law duties of good faith and elaborates on those. Those rules, good faith obligations imposed explicitly by institutional rules, which Eva referenced, statutory obligations like Section 40 of the English Arbitration Act, but also statutory provisions in other jurisdictions in Australia, in some of the geographical regions in Australia. There are statutory obligations of good faith. In Peru, elsewhere, there are statutorily defined obligations to arbitrate in good faith, and where you have an arbitration seated in those jurisdictions, that obligation needs to be complied with. And thus, like other aspects of international arbitration, the law of the sea can sometimes be important, and importantly different from what would be the case in other jurisdictions. But my third and final point is that notwithstanding those national differences, one can also discern an international principle of an obligation to arbitrate in good faith, which I would derive from the New York Convention. New York Convention, of course, in Article 2 imposed an obligation to recognize, and also on the parties to comply with, international arbitration agreements. Part of the obligations imposed by international arbitration agreements and given effect by Article 2 of the New York Convention is the obligation to arbitrate in good faith. That general principle is undertaken by all of the 169 contracting states to the New York Convention. They implement it in different ways, but importantly, and from a practical perspective, where national law hasn't crystallized or articulated the specific content of the obligation to arbitrate in good faith, the New York Convention can be used to fill the gaps. And importantly, and this is good for international arbitration generally, to try to fill them in a consistent manner. It won't be uniform for all the reasons that we said. The obligation to good faith depends upon the specificity of the parties' individual arbitration agreement and their commercial relationship. But the basic principles, I think, are discernible and also to a remarkable extent common across jurisdictions.
The next group of questions that have come in relate or return us to the question of sanctions for breach of the duty to arbitrate in good faith. Some of them ask in particular whether the panel has seen examples of a serious instance where an award has been made as a result of a sanction, say, made as a result of an adverse inference. Perhaps I can ask Darius to lead us off with his thoughts on this area. It is in sanctions for breach that the duty of good faith finds real teeth. What has your experience been?
So let's start with the adverse inference point. I don't recollect seeing any award solely based on an adverse inference. I mean, sometimes an adverse inference is thrown into the mix or the basket of evidence, but I don't believe I have seen an award which is solely based on drawing of an adverse inference on any major issue of fact in an arbitration. Sanctions are the key because that's the only thing that makes people act better. And I agree with Gary that we are talking about exceptional cases. Most cases, 90%, 95%, are run-of-the-mill, and that's a good thing because both sides are acting in good faith. But in those exceptional cases, it's the availability of sanctions that keeps a party, I think, in some kind of check or place. And there are many sanctions. Costs, of course, is the obvious one. And interest, I think, is another. So I know, for example, the Indian Act, and I'm just going back to my experience with the Indian Act. The Indian Act had a provision up to 2015, which put in a default rate of interest should the tribunal not fix its own rate. And of course, that was very high. Pre-2015, it was a default rate of 18% per annum. That's got amended to something more practical after 2015, which is 2% above the rate of interest prevailing on the date of the award. But that extra 2%, I presume, is the force of sanction that might drill some reason into a recalcitrant debtor to honor the award as quickly as he or she can, rather than incurring a higher rate of interest of that nature. So the other sorts of sanctions, again, you find, again, I draw my experience of the Indian Act, is treating the award as a decree of the court, which is what the Indian Act does, and giving you the full benefit of the entire menu of options for execution of decrees, including furnishing of security pending a challenge, deposit, sometimes going up to 100% of the awarded amount. These are all sanctions that can make a party think twice about taking up objections which are not really sustainable and which are made just to prolong payment. Sorry.
Yeah. Eva, one way in which breach of the duty to observe good faith in arbitration finds teeth is in the area of anti-suit injunctions, for example. If a party to an arbitration agreement insists on litigating in its national court, arbitral tribunals have been known to issue such injunctions. Would you say that that would be an instance of a manifestation of sanctions for the breach of that duty?
I agree it is a sanction. I'm not sure whether that is a manifestation necessarily of a breach of duty of good faith. Possibly. And I would also add that, in fact, I do agree with Gary that when it comes to adverse inferences, it may not be always easy for tribunals, just going back to the previous question, to actually find a breach of any positive obligation as a result of an adverse inference. However, an award is often a very finely balanced piece of drafting, and there's so much that goes into the drafting of the word that is sometimes not said. In other words, adverse inferences can be also an effective remedy to the extent that it informs a tribunal. It informs a tribunal's view, and as some arbitrators sometimes say, they tend to make a decision on the basis of what they feel is the correct legal result and what is the fair legal result. And then there's always ways of adapting the law to then provide for this result in the award. So I wouldn't say I would necessarily agree, but this certainly goes to say that, yes, adverse inferences can as well be effective.
Gary?
So just very briefly on the anti-suit injunction question, I think that a tribunal's order that a party not pursue litigation in breach of an arbitration agreement is less an application of the duty of good faith to arbitrate and more enforcement of what one might call, what is properly called, the negative effects, the negative obligations of an arbitration agreement. An arbitration agreement has two faces, a little bit like Janus. It has a positive face requiring the parties to arbitrate in good faith, and we've been focusing on, in a sense, the positive and constructive aspects of the arbitration agreement thus far. But it has a negative set of obligations, also one of them being not to litigate in national courts the disputes that you have agreed to submit to arbitration. An anti-suit injunction, in my view, rightly or wrongly, is an enforcement of the negative obligation. You promised you wouldn't litigate in national courts. You've gone off and done just that. We, the tribunal to whom you submitted these disputes, therefore enforce, give effect to your promise not to have litigated. There can be disputes, obviously, and I think they're particularly pointed between civil and common law jurisdictions as to whether anti-suit injunctions are the right or the wrong remedy. Same questions as to anti-arbitration injunctions, whether one shouldn't instead rely upon the wrongly chosen forum to enforce the agreement to arbitrate. I think they're beyond the scope of what we discussed today, but I think going back to your question, an anti-suit order by a tribunal is forcing the negative obligation not to litigate rather than the obligation to arbitrate in good faith.
Another set of questions that has come in focused on exclusion or possible exclusion of the duty of good faith, and whether parties can expressly exclude the duty of good faith in their arbitration agreements. A related question would be, what if a party says that it is not a party to the arbitration agreement? A party comes in and disputes the jurisdiction of the tribunal. Is there some remnant of the good faith in cooperation in arbitration? Difficult one, so I'm going to start with you, Gary.
Thank you. I think I'm not sure that I agree that a set of parties could exclude the obligation to arbitrate in good faith. The interesting thing is that you virtually never see parties do that. I think that is further evidence that, in fact, there is such a duty. Parties never in commercial practice would think, or at least virtually never, there may be cases I'm not aware of, virtually never think to exclude a duty of good faith. Imagine an arbitration agreement, we agree to arbitrate, but we explicitly exclude any obligation to participate in the arbitration in good faith. Would any commercial party agree to that? Would any commercial party propose it? I think not, because the whole point of arbitration agreements put into a contract during the happy honeymoon period is to resolve the disputes that you think will never arise and to commit yourself to resolving them in an expeditious, efficient, even-handed manner. Completely contrary to that at that point before disputes have arisen would be, we're not going to do it in good faith, actually. So I think, although strictly speaking, it's difficult to contest the proposition that parties could, in the exercise of their autonomy, exclude an obligation of good faith. They don't ever do it, and the reasons they don't underscore why we have this obligation of good faith in the first place.
Darius, just for the sake of argument, I would suggest to you that one such situation might arise where the two parties are represented by, say, common law practitioners who say that there's no good faith anywhere in a contract. They appear before a common law tribunal who are also of that view. And then the debate is, where is the duty to arbitrate in good faith?
I agree with that, actually, because, all of us who are born and brought up in a common law tradition, except for, of course, the judgments of some of the English courts, have not noticed a duty of good faith, especially in the law of contract. So this is something a bit novel to a common law lawyer. But I think all arbitration practitioners have grown up with some sort of a duty of good faith at the same time. And that probably comes from the New York Convention and the Uncitrall model law. So, which then puts us in this slightly hybrid situation. When you look at the contract, there's no duty for the party to act in good faith. But when resolving disputes under that contract, you do import that duty. So it does lead to some tricky questions. But again, I think processual good faith is something that's inherent in any common law lawyer as well. We practice before courts, tribunals. You have to cooperate with the tribunal. So as far as procedure is concerned, I think that's a no-brainer. As far as objections, as far as whether you're a party to an arbitration agreement or not, I think there are well-set rules. There are doctrines, the group of companies doctrine, which makes non-signatory parties and other such doctrines. And it's a question of applying those doctrines. I don't think good faith enters into that one, except to say that countries have now recognized that intention alone can make you a party to an arbitration, even if you haven't signed up to it.
And Eva, if that situation occurred to you and as an arbitrator, would you say that the Bremer-Fulkan case by the English courts might be the answer?
So on the first point about, it would be interesting to see the practical implications of a contractual provision that excludes a duty of good faith. And the first thing that comes to my mind is to see whether the actual application of such a provision would not go against some mandatory provisions, even under the English Arbitration Act. And similarly, it would depend what kind of institutional arbitration is foreseen, because if it's an ad hoc arbitration, perhaps that could be one thing. However, if it's an LCA arbitration and the consequence is that it goes against the LCA rules, then I see this getting problematic. That's on the first point. On the second point, though, I really wanted to add as well that when it comes to parties arguing that they're not parties to arbitration agreement, of course, that happens a lot. And we know that there's a big divide between common law and civil law systems, and especially France and England when it comes to who is and isn't a party to arbitration agreement. So I certainly wouldn't go as far as to say that a party that disputes, and often successfully, jurisdiction of a tribunal, I don't think that we can equate that to any bad faith conduct. I think it is their right.
Darius referred a moment ago to the award of interest being a possible sanction, and it's something I want to return to by saying that it was put to me recently by a third-party funder when I mentioned this event to them, that a possible way to give teeth to the duty to arbitrate in good faith and to honor the award is for tribunals to be more receptive to arguments on imposing interest on award debts at rates that are high enough to encourage immediate settlement of the award debt. I'm going to ask Gary and then Eva and then Darius what they think about this question of the award of interest being a possible sanction or to encourage observance of good faith in honoring the award. Gary?
Just very briefly, I know we're running short on time. I agree that interest as part of the tribunal's remedial authority in making a party whole when it's suffered a breach of either contractual or other legal rights is a critical part of providing a fair resolution to the party's dispute. Interest, it follows, I think, from that proposition, ought to truly make a party whole, not partially make a party whole, and in particular shouldn't be based on sort of an arbitrary transposition of national court rules for judgments to the arbitral tribunal. I think one has to approach the legal question of what the appropriate interest rate is with considerable care. I think one often forgets that interest rates are attached to particular currencies, and then the first and very important step is to make sure that you have an interest rate that is linked to the appropriate currency. Secondly, I think one has to use great care in choosing the applicable law. Is it the law of the seat? Is it the law governing the underlying contract? Is it some other law? But finally, the basic commercial principle that interest ought to repair the innocent party's damages and do so fully, ought, whatever the choice of law complications one faces, ought to be observed. I'm not sure that this is a direct result. In fact, I'm doubtful that this is a direct result of an obligation to arbitrate in good faith. I think it's rather a substantive damages principle. I nonetheless do think it is of applying the principles I've just referred to, I do think goes some way towards addressing the risks of guerrilla tactics and delay in the arbitral process, because the party that engages in that should be aware that it will ultimately bear the full commercial consequences of having done so.
Eva.
Well, I have very little to add, and I entirely agree with Gary, with what Gary has just said. I would only mention that I would also be quite cautious when it comes to tribunals' discretion, because of course there needs to be a good basis. There needs to be a good basis for applying a certain interest rate. Often that's in the contract, and if not, then the party certainly would need to be granted an opportunity to comment if tribunal were minded to go down the route of imposing an interest rate that would go well beyond the party's expectations, not based on contract, not based on any statutory provision. So that would be one caveat that I'd add.
Thank you. Darius, the court rate for the seat of arbitration that is Singapore is, many would say, is quite low compared to, say, the commercial interest rates of the parties to an arbitration. Is there a case to be made looking more at commercial interest rates?
Certainly, and I think I would agree with Eva on this, that I don't think there's any scope for a tribunal imposing some kind of a penal rate of interest at all. They have to award such interest as would compensate the party, and no more than that. And it would be very difficult for a tribunal to justify any rate higher than that on the ground that that will encourage parties to accept their award. I don't think that's part of a tribunal's remit at all. So that extra interest has to come from outside, either from the statute or from courts. It can't come from the tribunal. But yes, I think there is an immediate need, wherever it's not there, to move towards giving realistic interest rates and rates that are close to the commercial rate. Certainly.
Gary, I'm going to give the last say to you in this event and ask you what you see to be the future of good faith in international arbitration. Will it become, for example, a doctrine or principle that reaches the size of equal treatment and full opportunity of case presentation, or will it be a smaller star? Gary?
Thanks very much for that opportunity. And thanks also, Eva and Darius, for a very provocative and engaging conversation. It was a bit like a fox hunt or some other sort of sports event. I think your question, Lawrence, is very important and difficult to predict for the future. Good faith in arbitration, as I think all of our remarks has indicated, been observed widely in practice. We focus on due process paranoia, the exceptional case where things are pathological, either the pathologically drafted arbitration agreement or the arbitration that goes badly wrong because of party misconduct or tribunal inexperience. But in fact, as Darius explained, most arbitrations, 95% of them go smoothly, precisely because parties arbitrate in good faith. Given that, there may not be much need to develop the concept of good faith into a grand principle like fair and equitable treatment. All that said, it's important to provide safeguards against the exceptional cases of misconduct and guerrilla tactics. And I do think that the principle of good faith in arbitration, backed up by meaningful remedies, meaningful sanctions, is an important part of the solution to that. I agree entirely, exactly because it's a general principle and needs to be applied in specific circumstances that institutions and arbitral tribunals play a major role in giving concrete effect to that obligation. For example, providing remedies for a failure to pay in advance on costs. For example, a tribunal specifying in a procedural order the consequences of a failure to comply with time limits or disclosure obligations. So I think there's more to be done. I'm not sure, though, that the principle will ever rise to the type of importance that a prohibition against expropriation or a requirement for fair and equitable treatment currently enjoys.
Thank you, Gary. Ladies and gentlemen, I hope you enjoyed this Maxwell conversation. Watch out for our next Maxwell conversation, where we deal with another topic and challenge assumptions with a deeper examination of issues. It remains for me to thank our speakers, Gary Bourne, Eva Kalnina, and Darius Khambata, as well as our sponsors and supporting organizations, and for me to wish you a good day from wherever you are watching. Good day.